Today in this lecture we will see the certainties of certain matters in relation to the trust. When creating an express trust, it is important that the settlor acts with sufficient certainties. The settlor must demonstrate a clear intention to create a trust as opposed to creating something else. The trust property must be sufficiently segregated from other properties so that the trust fund is certain. The people who are to benefit from the trust must also be identified with sufficient certainty. Without such certainty, the trust will be held to be void. When considering express trust, the court may analyze the actions of the settlor as evidencing an intention to create the trust or express trust, even though he might not have understood what he was doing. In terms of the trust especially, the judge's concern is that the settlor makes his intention sufficiently certain so that the court will be able to direct the trustees how to act if there are problems with the administration of trust. It is important that the settlor intends to create the trust as opposed to creating merely a gift. The simplest manifestation of that intention would be for the settlor to take advice from a notary public and sign a formal deed of trust in the form of a deed. In such situation, if the settlor consciously intended to create a trust, then there is no difficulty in establishing that there was sufficient certainty of the intention. The more difficult situations are where a settlor unknowingly behaves in a way which might have created a trust, or where the settlor leaves his intention ambiguous in terms of a will or other documents. Now there are three certainties identified more than 100 years ago in an English case. That was the Knight versus Knight. In the Knight versus Knight, the Lord Langdale declared that for a trust to be validly created, three things were necessary. First one, the words that they have employed or what they have spoken at the time of transaction. The words employed must be coached, that taken as whole, they could be deemed to be imperative. Second thing is that the subject matter of the trust, that's the trust property, must be certain. As you know, without trust property, there can't be a trust at all. The objects or persons intended to be benefited must be certain. But in some other cases, when you see the circumstances like charitable trust, even though the people who are benefited or people who are intended to be benefited, not much certain it is identified as trust. But generally, some extent it should be identifiable. When creating a trust, it is an important that the settlor acts with sufficiently certainty. Settlor must demonstrate a clear intention to create a trust. Always we must be very careful how to identify the intention of the author of the trust. That's why it depends on the documents and the words that they have spoken at the time of execution of transaction or deed. The trust property must be sufficiently segregated from other property so that the trust fund is certain. There are cases where the property transferred from one person to another. It doesn't mean that there's a trust. It may be a gift or it may be transfer or whatever it is. At the same time, if there's a trust money, if that money deposited in the trustee's account with his money, his own money, then there can't be a trust. Because always trust property must be segregated from other property. Finally, the people who are to benefit from the trust must be identified with sufficient certainty. That's very much sufficient certainties. Then come to the section 6 of the trust ordinance. Subject to the provisions of sections 5 and 107. This section is subject to those two sections. This section is section 6 of the trust ordinance, which is subject to other sections, sections 5 and section 107. As we have studied under express trust, section 5 of the trust ordinance speak about express trust. Section 5 of the trust ordinance speaks about express trust. The first one we have seen, 5.1, in relation to the immovable property. That's why we have seen that should be executed by notary public, because it should be in writing and notarially executed. That's the words that they have used in section 5.1. 5.2, that is in relation to the movable property. That is in relation to the movable property, then that should be in writing but not notarily executed. If the property delivered to another person, that's enough. No need to execute in front of notary public with the witnesses. Then here, subject to the provisions of sections 5 and what is 107. 107 is de facto trust. The court has the power to declare there's a trust. In material of section 5 and section 6, the power is given to the court. If there is a trust, then the court will declare that trust is existing. A trust is created when the author of the trust indicates with reasonable certainty. That's very important. That's why I highlighted in this one. With a reasonable certainty by any words or acts. By any words that must be in writing or even spoken. But another one is very important, even by acts. Then the reasonable certainty of what? The intention of the author of the trust. Because, simple example here, now, if I transfer my property to another person, alright, now I transfer my property to another person without saying anything. It means that it may be a deed of transfer or deed of gift. There is no trust at all. The same way, I transfer my property to another person and set certain things. You must look after so and so. You must give out of the property whatever money you earn from the property. You must give to somebody else for the benefit of somebody else. There are something what I have spoken at the time of execution. Then what is my intention? Even though prima facie there's a deed of transfer, but really speaking, that's not a deed of transfer, that's a declaration of trust. That's why intention of the author of the trust to create a trust is very important. Then come to the purpose of the trust. Always there must be a purpose. If the trust is created, then for what? To the benefit of somebody. Then who is the beneficiary? Generally, beneficiaries must be identifiable. That's why in 2018 Amendment Act says some extent a person must be able to ascertainable the beneficiaries of a trust. Then finally, that's a very important trust property. As you know, if there is no property, then there is no trust. Property is the backbone of a trust. Suppose if you don't know the trust beneficiaries, then the trustee must hold the property for the benefit of author of the trust. Then the resulting trust arising. But here, if there is no property, then there is no trust at all. And unless the trust is declared by will or author of the trust, is himself to be a trustee, transfer the trust property to trustee. If the author of the trust is one of the trustees there, then there is no requirement to deliver the property to another person, because the owner of the trust, the owner himself, becomes a trustee at all, trustee. Then no need to transfer the property or deliver the property to anybody. Now we will move to other slide here. Then here what we are going to see, the section refers, section 6 that we have seen now, refers acts also. That means the trust may be created by words or by acts. The express trust under 5.1 could not be created by acts alone, because the section itself requires it should be in writing. Even if you see section 5.2, it should be in writing. But it is possible under section 5.3, because 5.3 provides that these rules do not apply where they would operate as to effectuate a fraud. That's very clear. No trust is valid. That's the way section 5.1 and 5.2 starts or begins. That's a mandatory requirement. The trust should be in writing. But there's an exceptional circumstances provided in section 5.3. That is, these rules, that means the rules specified in section 5.1 and 5.2 do not apply where those two rules, 5.1 and 5.2, would operate so as to effectuate a fraud. In order that a trust may be valid and enforceable at law, the intention to create the trust must be indicated by words or acts with reasonable certainty. Then always, there's a big issue in the deed to interpret whether there's an intention to create the trust. The language used must be clear enough to show the intention to create the trust. Always we must be very careful when you interpret the documents, maybe a transfer document, maybe a gift, deed of transfer or deed of gift, or sometime wills. Such a way we must interpret and identify the intention. We should not interpret the word in isolation. We must interpret the whole document, then come to the intention of the author of the trust. These are the certain circumstances or illustrations given under Trust Ordinance to section 6 of the Trust Ordinance. When you read one by one, there are some precatory words given, like full as confidence or hoping or requesting or desiring. These are the words that they have used. But there are certain circumstances trust is created. There are circumstances trust not at all. See the first one. A, bequeaths certain property, bequeaths certain property to B. Having fullest confidence. That's very important. That's why it is in the within the inverted commas. Having fullest confidence that he will dispose of it for the benefit of C. Then the fullest confidence and for the benefit of C. It's clear more enough. Because certain property, even though certain property in the sense, when you see this illustration, certain property, it's clearly specified. These are the properties, 1, 2, 3. 1, 2, 3. Those are the properties. Then certain property, number of property, given to B, bequeaths to B, having fullest confidence that he will dispose it for the benefit of C, who is the beneficiary. That's the thing here. C is the beneficiary. Then when you apply the section 6, in examination, you must see this is a way you must approach. First of all, you must see the facts, whatever given in the examination paper. Now here, if you think about this one, take this illustration and apply the section. Intention to create the trust in his part of the author of the trust. When you see the section, the illustration here, having fullest confidence, that's the idea here. He will dispose it for the benefit. That means very clearly there's an intention to create the trust. What is a trust property? That's the certain property, specified certain property. Then that's clear. Trust is B, very clear. The property transferred or the property bequests to B, that's clear. Then the intention is clear. From the fullest confidence, he will dispose it for the benefit of another person, that's clear. Those are the words. Give an idea to interpret, give an idea to come to the conclusion that there's an intention to create the trust. Then intention part is clear, property is clear, trustee is clear, beneficiary is clear. That's why the illustration says this creates a trust so far as regards to A. Then come to the paragraph or the illustration 2. A bequeaths certain property to B, hoping, that's a precatory word, hoping he will continue it in the family. Again you apply certain property, ABC property is clear, trustee is clear. Then what the problem here? In the family. What is the definition for family? Maybe father and mother, or husband and wife, or sometimes husband and wife and children, or sometimes maybe grandmother, grandfather. It goes like that. We don't know really. Then even though the intention, some extent you can say hoping he will continue it for the family specified there. But the problem is then the thing is when you say hoping he will continue it in the family, in the sense some extent we can identify that there's an intention to create the trust in his part or in the part of author or settlor. But the other issue is whether property is clear, certain property, ABC property, that's clear. Trustee is clear. But here, how to identify the beneficiary? That's why here in the illustration, it says that this does not create a trust as beneficiary is not indicated with reasonable certainty. Then go to the illustration 3. A bequeaths certain property to be requesting, that's very, again, precatory words. Requesting him to distribute it among such members of C's family as we should think most deserving. Now again problem. As I told you here, again apply the section 6. Intention, some extent we can say there's an intention to create the trust. Because we're requesting him to distribute it among such members. Then those are the words put together and interpret those words. Some extent or certain extent we can say there's an intention to create the trust. Then the property is clear. ABC is certain property. Trustee is clear. Again the problem is trustees. Again the problem is beneficiary. How to identify the beneficiary. Members of C's family. Members. Who are the members? Father, mother, husband, wife, children, grandmother, grandchildren. Oh, why? We don't know. Sometimes maybe the whole society. And again, we should think most deserving. What are the criteria to decide? We don't know. Then in these cases, we come to the conclusion that there is no certainty in relation to the beneficiaries. That's why the illustration indicates that this does not create a trust. for the beneficiaries are not indicated with reasonable certainty. Then we will go to fourth one, that's a fourth illustration given to section 6 of the trust ordinance. A bequeaths certain property to B, desiring, that's important, again the words, precatory word, desiring him to divide bulk of it among C's children. Now again apply, as I told you, the section 6. Property is clear, intention some extent clear, because desiring him to divide. Those are the words here. When you put together all, desiring him to divide the property, when you say this one, the intention, there's some extent we can say there's an intention to create the trust. Then what the problem is here? Trust is clear, property is clear, intention clear. Now trust property. What's a trust property? Bulk of it. C is children, that's the beneficiary. Then C is there. C is children, simply you can identify who are the ABC, then that's fine. The beneficiaries are identifiable. But the problem here, how to identify the trust property, bulk of it. What is the bulk? How to interpret bulk of it? That's why the illustration specify that this does not create a trust, for the trust property is not indicated with sufficient certainty. Finally, the last illustration given to section 6 of the trusts ordinance, A bequeaths a shop and stock in trade to B on the condition that he pays A's debts and legacy to C. It's very clearly said that the conditions are totally different from trust. The conditional transfer is there. Even in the deed of transfer, there are circumstances under which the notary executes deed of trust or conditional deed of transfer. Then there are conditions. You have to fulfill those conditions. Those are conditions, not the trust. That's why here also said like that. Now we will move to other section. This is the main part that we are going to see now. How to identify the intention to create the trust. How to identify the intention to create the trust. When you see the section 6 again, I would like to highlight here, a trust is created when the author of the trust indicates with a reasonable certainty by words or acts with the intention in his part to create thereby a trust. That's the intention. Not only in the knight versus knight case, in the English case, the first time, more than 100 years ago, specified certain matters should be certain or clear. But here in section 6, in the trust ordinance, again, specifies the important certainty of certain matters. The first matter here, intention to create the trust in his part. A trust is created by author of the trust, then we must identify the intention to create the trust. It may be by words or acts, whatever it is. In construing a terms of a deed, the question is not what the parties may have intended, but what is the meaning of the word that they have employed or used in the document. That's very important. They may have different ideas, may have different intention. We don't know. Then how to identify their intention? Always, as we have studied in the interpretation law, always we must interpret the words, those are in the legislation or in the wills, to identify the intention of the author of the trust, author of the person, or in the case of legislation, we must identify the intention of the parliament. The wills, we must identify the intention of the testator. Those are the ideas here also. In construing the terms of deed, the question is what the parties may have intended. They have intended, may have intended so many things, but we don't know. Then what we should do? What is before us? The deed is before us. Then we must see the deed and what are the words that they have employed or used in the deed, then interpreting those words and come to the conclusion that what type of intention that they had at the time of creation of that document. It is not necessary at all to use or non-use of word trust in the document. Like in the computer, just you type the word trust and search for in the document. See, there is no trust word, then come to the conclusion there is no, that's wrong at all. Then what you should do? There is no requirement at all to use the word trust in the document. Whether you are using or not, even sometimes parties used that word trust in the document, it doesn't mean that it created a trust. Sometimes there is no word at all, there is no word trust in the document at all, but it may create trust. That's why the use or non-use of word trust in the document is not indication of the intention of author of the trust. There is no formal language, that's very important. No formal language is necessary to constitute the effective declaration of trust. But the language used must take it certain that settlor intended to constitute a trust binding in law on himself and the person to whom the property was given. There is no formal language, that's the issue. That is the examination also. That is a test at all to identify the intention. If there is a formal language, then there is no issue at all. There is no test at all, because you can search for the words. If the word appears, then there is a trust. But there is no such case here. There is no formal language at all. Whether you are using the word trust or not, non-use of the word trust, it doesn't matter, whatever it is. You must identify, the court must identify the intention of the author of the trust from the whole document, what they have written, from the words what they have employed, or from the words that they have used in the document. That's why here we say that there is no formal language at all. Then always we must see the language that they have used there in the document and try to interpret those words for the purpose of identifying the intention to constitute a trust binding in law on himself and the person to whom the property given. Use of words trust or trustee is not essential to create the trust. That's very important. Use of words trust or trustee is not essential at all to create a trust. Even the words by settlor are in precatory form, the trust will come existence. That's why we have seen in the illustrations. Hoping, desiring, fullest confidence, all these things, certain cases, what we have seen in the illustration, trust created. That's why the use of words, trust or trustee, is not essential at all. In addition to that, where the words by the settlor are in precatory form, the trust will come existence. Where the words used in the instrument do not indicate with the certainty an intention to create the trust, then no trust can come into existence. Trust may be created by any language, any form, sufficient to show the intention or by contact of parties. Dr. J.M. Hooray noted as follows: though for the sake of brevity, we refer the intention of settlor, it is more correct to speak of the settlor's manifestation of intention to create the trust. Manifestation of intention to create the trust. What they have expressed from the words. We say simply intention of the author of the trust, intention of the settlor, but very clearly we must keep it in our mind. We must identify the intention from the words what they have manifested. Alright, now we will move to other slide. Fernando versus Jossie, 50 NLR 140. The court cited Indian case, Maharaja Manindra Chandra Nandi versus Raj Durga Prashad Singh. What is said there? In construing the terms of a deed, the question is not what the parties may have intended. Again, in Indian case, cited in Sri Lanka court. In construing the terms of a deed, the question is not what the parties may have intended, but what is the meaning of the words which they used. Then always, intention of the settlor in the sense, we must identify the intention from the words they have used in the trust deed. Settlor may use words precatory or recommendatory or expressing a belief. When you see these illustrations, desiring, hoping, having some sort of fullest confidence, these are the words. So there are precatory words, recommendatory words, or expressing some belief. I believe, I trust, when they mean to declare trust. The example given in the illustration, what we have discussed now, here again cited. Just you see that when I don't want to spend the time on that, I'm moving to another slide. Then Paul, in that 1977 case, there must be clear declaration of trust, and that means there must be clear evidence from what is said or done of an intention to create the trust. Now what we have seen up to now, there are issues, there are documents, there are transactions. Then we must interpret the words. There are some moral obligation. That's a moral obligation. It amounts to trust, not always. That's why the heading given here, moral obligations or trust. Then how to identify the moral obligation as well as the trust. Now we will see the differences or the situation under this one. Now here we must identify the moral obligation different from fiduciary obligation. There's a difference between merely imposing a moral obligation on a person who is the recipient of property and imposing formal and fiduciary obligations on that person such that they become a trustee over that property. And this is a big difference that we must understand, first place. Whether the document imposing moral obligation to the receiver of a property, then it's just an obligation. You to do this one. But sometime imposing the fiduciary obligations, then it must be a trust. It is possible for one person to impose a moral obligation on another person in relation to the use of property without that necessarily constituting the condition or trust. It is possible that as the part of making a gift to someone, the donor will seek to impose the moral obligation on them. Then how to identify whether it is a moral obligation or it amounts to the trust, the fiduciary obligation. Moral obligation, fiduciary obligation. Moral obligation also, in certain cases, certain circumstances, it amounts to the fiduciary obligation. Then we must identify from these examples or cases. The expression generally used by courts to distinguish between a declaration of trust and moral obligation is to define merely moral obligation as setting out precatory words. Merely precatory words do not create substantive trust obligation. See these two cases now, then you can understand the moral obligation and fiduciary obligation. In the case of Visalachi Pillai versus Sivahami Ammal, 114, a deed of gift was subject to following among other conditions. The deed of gift, right? Sometimes deed of gift amounts to the trust, sometimes may not be, that we don't know from the conditions. If it is moral condition, then it is not. If it is fiduciary conditions or fiduciary obligations, then it's a trust. Then we will see the said donor shall have the power to sell or mortgage or otherwise alienate or encumber the said lands and premises. In the event of said donor dying, leaving behind said lands and premises, then it shall be obligatory on the said donee to pay out of the land and premises a sum of 500 rupees to S. Now the issue is here, donor has the full power. Even the property gifted to somebody, the donor shall have the power to sell or mortgage or otherwise alienate or even encumber the said land. That's one side. But if the donor dies, leaving the property, then there shall be obligatory on the said donee to pay out of the said land and premises the 500 rupees to S. That's the facts. It was argued by the plaintiff, the respondent, that the whole transaction seems almost in illustration of the definition of trust as set out in section 6 of the trust ordinance. The property will otherwise have to be sold and the money paid out of the proceeds in order to comply with the terms of the deed, creating a trust. A refusal to pay sum would be in fraud of trust. Then one side, the plaintiff respondent argued that it is more or less similar to the illustration given under section 6. The defendant appellant argued that the gift, this is a gift subject to condition, is all we have here. Now here the one party argues that it is a trust. It is similar to the illustration to the section 6. It created a trust. Another party simply said that no, this is a conditional gift, that's all. It is a class of donation well known to the Roman Dutch law. And in such a case, the court will apply the common law in order to determine the rights and liabilities of the parties who must deemed primarily to have intended to create a common law obligation. Now there is an obligation or condition. Condition in the sense where one side condition, other side obligation. The court said that now the legal ownership has to be vested in the person who has designated the owner. The language, however forcible and full, may be invoked to vest the ownership without affecting the intent to create the trust in favor of another. This will explain the use of words absolutely forever. That's very important words. Absolutely forever. You must put together this word also and then decide and interpret the intention. This done, there must be words to indicate a beneficial enjoyment of whole or part of the property by another. This would appear the words out of said land and premises satisfies the requirement specified in section 6. And Koch J said, I should wish to emphasize firstly the words upon the condition in the passage quoted, for this will explain the presence of the words subject to the conditions in the deed in question. Secondly, the requirement that the condition must be performed and satisfied out of the property. Performed and satisfied out of the property. We have these words in clause 3 of the deed. The essentials to create a trust are present. Therefore, I hold that there is a trust has been created. Now, when you see this case, even though the words that they have used contradictory, court has come to the conclusion. The contradictory in the sense, in one place, the document specify the words or use the word absolutely forever. Once the property absolutely forever given to somebody, there is no trust at all. But in other side, when you see other words that they have used here, out of the said lands and property. Performed and satisfied out of the property. These, when you emphasize these words, then the trust is created. Now we will see another case that also closer to this one, slightly different. However, more stricter and correct test was applied in Armukampillai versus Velupillai. 46 NLR, page number 241. In this case, where a deed of gift contained the following conditions. What is the condition? First one, that the said V.S., the name of a person, shall look after said properties and take rents and profits of said properties and perform Ardhasama Pujava, which is being generally performed and which now we are performing, and also Tirtham festival in the temple standing in the land. Now, when you read this one, we don't know whether there's a fiduciary obligation or the condition. We don't know. Now, when you see this one, take rents and profit, one side. Second, perform Ardhasama Puja. There's a puja, perform. Now we are performing, and future also you must perform. And third one, Tirtham festival in the temple standing there. Second, that after lifetime of said VS, lifetime of VS, the person who was appointed by him in his place, in default of such appointment, the eldest child of descendant will have the right to perform the duties of said temple. Now, when you read the second condition here, once the VS dies, then the condition or the obligation or the duty goes to another person, heirs of VS. See the section, see the third condition. Said VS will have no right to sell or transfer said properties or alienate the same by documents in his lifetime. He can't sell it or alienate it. Finally, that whenever he in his lifetime appoints a person whom he likes, he shall have appoint such person subject to binding recited in the paragraph. Now when you see here, the court held that the condition annexed to the deed were not sufficient to create a trust. Why is that? What's the difference between two cases now? Sivahami that we have seen, Armopilli we have seen. Sivahami also, there are some there are some conditions, but it amounts to the trust. But here the court said there is no trust. The reason behind this one, when you see this one once again very clearly, it's very clearly indicates that the conditions takes rents and profits, that's one side, and perform the puja and perform the Tirtham festival. Then one side you take rents and profit, that's fine. Then you do certain things. Then to do certain puja, in the sense, that's a condition, because it doesn't speak about whether there's expenses incurred in relation to the performance of puja. if it is proved that there's expenses in relation to this performance of puja, then definitely it must be a trust, because then out of that property, the profit and rent gained out of that property should be utilized for this one. Then there's a trust. But here, once a property is given, the conditions given, you can't sell it, you must, if you die, then what should you do? And do the performance of puja and performance of festival in the temple. Those are the conditions, because the court couldn't identify whether there's expenses incurred in relation to those puja. That's why in Murugesu versus Chellaya, HMC Fernando cited this Kadiresu Ambalawanas versus Subramanian Kadirevelu and said that the Bertram CJ said in that case, when a person who is the owner of the property purports to transfer it to the temple, the effect of his doing is to constitute himself a trustee to the temple. This is something very wide interpretation. If a person, the owner of the property, transfers his property to the temple, the effect of doing so is to constitute himself as a trustee, and then there is a trust. The document of dedication, in fact, declaration of trust. Dominion remains with the dedicator and passes on his death to his heirs subject to trust. Where the transfer of immovable property contained a recital that the consideration was paid by trustee for specified Hindu temple, held that transferee must be taken to have purchased property with the funds provided by or held by him for religious charity represented by temple. The transferee therefore held the property as trustee. On his death, the land devolved on his heirs subject to same trust. Therefore, the words for the temple were not merely precatory, but were sufficient to create a trust. Now we will stop with this one, then we will continue later. Thank you very much.